Welcome back, everybody. So, today we will be doing Order 34, Order 35, and Order 36. Order 36 read with Section 90, which talks about friendly suits. Then we have Order 35, we have interpleader suit. And then 34, we have suits relating to mortgages of immovable property. This is our today's agenda, and we will be completing this from the Bare Act, from the perspective of prelims. Let's start. Order 34 relating to mortgages of immovable property. Can you comment down the below under which section of TPA we can find the mortgage section? How many types of mortgages are there? Now coming back to Order 34, Rule 1, parties to suit for foreclosure, sale and redemption. All these sections are important. If you guys want, we can do mortgage after this, alright? So parties to suit for foreclosure, sale and redemption, subject to the provisions of this code, all persons having an interest therein, either in mortgage security or in the right of redemption, shall be joined as parties to any suit relating to the mortgage. Though the persons having interest in mortgage security or the persons having the right of redemption can be joined as parties to the mortgage suit. A pucine mortgage may sue for foreclosure or sale without making prior mortgagee a party to the suit, and a prior mortgagee need not be joined in the suit to redeem a subsequent mortgage. And a prior mortgagee need not be joined in a suit to redeem a subsequent mortgage. A simple question: who is a pucine mortgagee? Who is a pucine mortgagee? And if I am pronouncing this is right, so he may sue without making the prior mortgagee a party, and a prior mortgagee need not be joined as a party to redeem a subsequent mortgage. Rule number 2, preliminary decree in foreclosure suit. In a suit for foreclosure, if the plaintiff succeed in the suit for foreclosure, the court shall pass a preliminary decree ordering that an account be taken of what has due to the plaintiff at the date of such decree for principal and interest on mortgage, the cost of the suit if awarded to him, and other costs, charges and expenses properly incurred by him up to that date in respect of his mortgage security, together with interest thereon, declaring the amount so due at that date, and directing that if the defendant pays into court the amount so found or declared due on or before such date as the court may fix, within 6 months from the date on which the court confirms and countersigns the account under subclause A. It says that in the suit for foreclosure, a preliminary decree can be passed by the court. Now, what will the court order? Court will order that account need to be taken into consideration, and that account would be principal and interest, any cost or any other cost like charges and expense which has been incurred by the plaintiff, declaring so due at that day, so due at that date. Now the court can also direct. Court can direct what the court is directing, that if defendant pays into the court, if defendant pays the amount into the court, the amount so found or declared due on before the such date, the court may fix within 6 months from the date on which the court confirms and countersigns the account and taken under clause A, or from the date on which such amount is declared in the court B. The case may be therefore pay such amount as the may be adjudged during the subsequent cost. In Rule 10, together with the subsequent interest, the plaintiff shall deliver up to the defendant or to such person as the defendant all documents in his possession or power requiring the mortgage property, documents returned. Okay, and shall if so required retransfer the property to the defendant plus retransfer the property at his cost, free from the mortgage, from all encumbrances created by the plaintiff for any persons claiming under him, or where the plaintiff claims by the right title by under whom he claims, if necessary, put the defendant in the possession of the property, and if the payment of the amount found or declared due under preliminary decree is not made on or before the date so fixed, the defendant fails to pay within such time, the code in subclause 1c, defendant paid the amount. In subclause 2, defendant did not pay the amount. The court may fix time the amount adjusted during the subsequent cost, charges, interest shall be entitled to final decree debarring the plaintiff from all rights and to redeem the property. Now the defendant would be debarred from having any interest in the property. The court may on good caution and upon terms to be fixed by the court from time to time at any time before a final decree is passed, extend the time fixed for the payment of amount found declared and the amount that is in respect charging expense interest. Where in suit for foreclosure, subsequent mortgagees or persons deriving title from or subrogated to the rights of any such mortgages are joined, the preliminary decree shall provide for adjudication of the respective rights and liabilities in such manner. Form 9 and 10 as the case may be of Appendix C with such variations as the circumstances as the case may require. Final decree in foreclosure suit, where before a final decree debarring the defendant from all right to redeem the mortgage property has been passed, the defendant makes payment into the court. The defendant makes the payment of all amounts due from him under sub-rule 1-2. The court shall on application made by the defendant who will apply for the final decree, defendant and listener pass a final decree ordering the plaintiff to deliver the documents to in the preliminary decree and necessary order him to retransfer at the cost of defendant the mortgage property as directed in the said decree, and also if necessary order him to put the defendant in possession of that property. Where the payment in accordance with sub-rule 1 has not been made, the court shall on application made by the plaintiff on this behalf pass a final decree declaring that the defendant and all persons claiming through is debarred is not been made, payment not. Now everyone is debarred from claiming the or redeeming the mortgage property. Passing the final decree, all liabilities which the defendant is subject to in respect of the mortgage or account shall be deemed to have been discharged. Preliminary decree in suit for sale. In suit for sale, if the plaintiff succeeds, sale, the court shall pass a preliminary decree to the effect mentioned clause ABC of the sub-rule 1 and 2. Further, directing that in default of the defendant being interim therein mentioned, the plaintiff shall be entitled to apply for final decree. Now that he will be applied if failed. If failed, apply for final decree. Directing the mortgage property sufficient value to be sold and the proceeds of the sale after deduction therefore makes sense of the sale be paid into the court and applied in payment of what has been contracted in the preliminary due to the plaintiff together with such interest entitled to be paid to the defendant, the person that received. The court may on the good caution upon terms raised with the court from time to time. Extend the time fixed for the payment of amount found declared to be dead or of amount adjudged due in respect to the subsequent cost changes. Power to decree sale in foreclosure suit. In a suit for foreclosure, in the case of a anomalous mortgage, if the plaintiff succeeds, the court may, at the instance of any party to the suit or of any other person interested in the mortgage security, right of retention, pass a like decree. On such terms as the things including the deposit in the court for a reasonable sum fixed by them to be and secure the performance of the terms in a suit for sale or suit for made order. The subsequent mortgages, the person deriving title from or subjugated the rights of such mortgages are joined as parties. The preliminary decree referred shall provide for the adjudication of respective rights and liabilities. Final decree, where on or before the, I think that was the fourth subclause 3. Okay. Where on before the day fixed at any time before the confirmation of sale made in persons of final decree passed at 3, the defendant makes payment in the court, paid the court all due. The court on application made by the defendant pass a final decree if such decree has been passed in order plaintiff to deliver up the documents, retransferring the mortgage property, put the defendant in possession. Where the mortgage sold in persons decree passed, the court shall not pass an order unless the defendant, in addition to the amount mentioned somewhere, deposits in court the payment to the purchaser sum equal to 5%. This can be asked, sum equal to 5%. Purchase money paid in court by the purchaser, where such deposit has been made, the purchaser shall be entitled to an order for repayment of the amount for purchase money with sum equal to 5% thereof. Where the payment in accordance with sub-rule has not been made, the court shall on application pass a final decree directing subsequent recovery of balance due on mortgage and suit for sale. Where the net proceeds of sale held as insufficient to pay the amount due on the plaintiff, the court on application by him, if the balance is legally recoverable from defendant, otherwise than the property sold, pass a decree for such balance. 7. In redemption suit. 7 we have redemption suit, and it talks about pre. If plaintiff succeed, pass ordering on account, same directing within 6 months, payments of fixed. Usufructuary mortgage, a mortgage by conditional sale anonymous, the terms which provide for foreclosure only and not for sale, the mortgage property be sold. In the case of mortgage by conditional anonymous, as before, the plaintiff is debarred from all the rights to redeem the property. Final decree, same. Recovery of balance, same. 9 decree where nothing is found, due or wait is overpaid. Cost, subsequent power of court or direct mortgagee to pay mesne profits, mean profit, where in suit for foreclosure, mortgagee to pay mean profit. 11 is payment of interest. In a decree passing a suit when the interest is legally recoverable, the court may order payment of interest. The date on before the payment amount due, declare due, order the payment to be made before otherwise person redeeming the mortgage. Sale of property subject to the prior mortgage. When a property sale is directed, court with the consent of the prior mortgagee, direct with the consent of the prior mortgagee, like the property to be sold free from the same, giving such prior mortgagee the same interest in the procedure of sale as he had in the property sold. Application of proceeds. All these are not, order 34 is not relevant for your pre-exam, not for the mains exam, alright. But you should be aware of this. Next is 14, suit for sale necessary for bringing mortgage property to sale. Payment of money in satisfaction of claim arising on the mortgage. He shall not be entitled to bring the mortgage property to sale otherwise than by instituting a sale and enforcement on the mortgage. Shall apply to any territories which has not been extended. By title deeds and charge, all the provisions contained in this order which apply to simple mortgage shall for us may be applied to the mortgage by deposit titles within the meaning of section 58 to a charge with the meaning of 100 for 100. Decree order payment of court charges on default of payment. 34 is not important. You just need to go through it once just like I did. And if there is any question, then I'll have a separate video on expected questions order wise, like from this order to this order we'll have these many questions like this question, so we'll be doing that. Next is order 35, interpleader suit. This is important, this is asked many times. Plaintiff interpleader suit. In every suit of interpleader, the plaintiff shall, in addition to statement necessary for plaintiff, state. Interpleader 35, plaintiff in addition to statements necessary, it should also state what all the necessary are ingredients of interpleader suit. That the plaintiff claims no interest in the subject matter in dispute other than for the charges or cost. Basically, what is an interpleader suit? Can someone write in the comment the section number? Now, in interpleader suit, plaintiff versus defendant and defendant. Plaintiff has no interest in the suit. He is ready to deliver the subject matter. The real dispute is between these two defendants. Okay. And the plaintiff claims no interest in the subject matter in suit other than for the charges or the cost. The claims made by defendant severally, they are severally making the claims. There is no collusion between the plaintiff and any one of the defendants. These particulars need to be there in the plaint. Payment of things claimed into the court. Where the thing claimed is capable of being paid into the court or pays in the custody of court, the plaintiff may be required to so place it before can be entitled to any other suit. Before he can be entitled to any order to the suit. Procedure where defendant is suing plaintiff. Where any of the defendants in an interpleader suit is actually suing the plaintiff in respect of the subject matter of the such suit, the court in which the suit against the plaintiff is pending shall, on being informed by the court in which the interpleader suit has been instituted, stay the proceedings as against him, and his cause in the suit so stayed may be provided for in such suit. But if insofar as they are not provided for in the suit, they may be added to his cost incurred in the interpleader suit. So that suit would be stayed. 4. Procedure at first hearing. At the first hearing, this is important. At the first hearing, the court may declare that the plaintiff is discharged from all liability to defendants in respect of the things claimed. But all things would be done. Plaintiff discharged from all liabilities. First hearing. In the first hearing itself, we will be doing these things. That plaintiff is discharged from all liabilities. to the defendant in respect of the thing claim. Second, we'll award him the cost. And dismiss him from the suit, and straight away we will dismiss him from the suit. These are the things that we will be doing at the first hearing. Court may, but if it thinks that justice or convenience so require, retain all parties until the final disposal of the suit. But he cannot dismiss, and he will retain all the parties if the justice or convenience so requires. Where the court finds that the admission of the parties or otherwise evidence enable it to do so, it may adjudicate the title to things claimed. Whether the court finds that admission of parties or other evidence enable it to do so, then at the first hearing itself, he can adjudicate upon the, fourth point, he can adjudicate the title. At the first hearing, he can adjudicate title. And on what grounds? If the admissions so require, if the admissions are sufficient and evidences are sufficient. Where admission of the parties do not enable the court. Now it does not enable the court to adjudicate. Now the court may direct that an issue or issues between the parties be framed. Now fifth point can be framing of issues. Okay, framing of issues can be the fifth point. Be framed and tried that any claimant be made plaintiff in lieu of it in addition to the original plaintiff. Now any claimant would be made the plaintiff and shall proceed. After this first hearing procedure, the court shall proceed to try the suit in ordinary manner. So this is important. Your fifth, the order 35, that is inter pleader suit. Order 35 inter pleader suit is in itself is important. Okay, pay a little more attention to it. Fifth, agents and tenants may not institute inter pleader suit. Nothing in this chapter shall be deemed to enable agents to sue their principals, tenants to sue their landlords for the purpose of compelling them to interplead with any persons other than the person making claim to such principals or landlords. A deposits a box of jewels with B as his agent. A C alleges that the jewels were wrongfully obtained for him by A, claims them from B. B cannot institute an inter pleader suit between A and C. A deposits a box of jewels with B as his agent. He then writes to C for the purpose of making the jewels a security for a debt due to himself to C. Afterwards alleges that C's debt is satisfied and the C alleges the contrary. Both claim the jewels from B. B may institute an inter pleader suit against A and C. Now tell me why this happens. He has deposited the box as agent. He then writes to C for the purpose of making the jewels as security for a debt due from himself to C. A afterwards alleges that C's debt is satisfied and the C alleges the contrary. Both claim jewels from B. Now just a second, okay. I have to you were on the order 35, right? So we need to go a little more down. This is important illustration being. This is only written, nothing else. Okay, now we have to figure it ourselves. So A deposits box of Jew B as his agent. He then writes to C for the purpose of making the jewel security for debt due from himself to C. A afterwards alleges that C's debt is satisfied and C alleges the contrary. Both claims are due from B. Then B may institute a suit interplead against A and C. We have charges for plaintiff's costs. So where the suit is properly instituted, the court may provide for the cost to the original plaintiff by giving him a charge on the thing claimed in some other effectual way or in some other. So it is very small. Order 35 only have rules. 6 rules we have. In the first, we just describe what we need to state with the plaint. In second, we just state that payment of the thing. If that it was a watch, then just deposit it in the court. 3, we if there is a separate suit which is going on, and that would be stated. 4, we have procedure of first hearing. 5th, we have the tenants and interpleader suit limitation. And 6, we have charges to the plaintiff's cost. Alright, we will create a charge to the plaintiff cost. Now we are at order 36. It is important. It is read with section 90, that is friendly suits. They are friendly suit. Both the parties are actually they are not at issue, but they are having difference in their opinion, and that's why they have referred the matter to the court. Power to state case for court's opinion. Parties claiming to be interested in the decision of any question of fact or law, so it could be a question of fact, it could be a question of law, may enter into an agreement in writing, stating that such question in the form of case or opinion of the court, and providing that upon the finding of the court in respect to the such question, what will happen, a sum of money fixed by the parties. They have already fixed fixed amount to be determined by the court shall be paid by one of the parties to the other. Some property, either immovable or movable, delivered by one party to the other, or that shall do or refrain from doing particular act so specified in agreement. Every case stated on this rule shall be divided into consecutively numbered paragraphs, shall concisely state facts and specify such documents, decide the question raised thereby. Whether value of subject matter must be stated, the delivery of any property for doing, refraining from doing any particular act, estimated value of the property to be delivered or to which act specified shall be stated in the agreement. Agreement to be filed and registered as a suit only. Okay, the agreement, if framed in accordance with the rules herein before contained, may be filed with an application in the court which would have jurisdiction to entertain a suit, the amount or value of the subject matter as the same as the amount of the agreement. The application shall be numbered and registered as a suit between two or more parties claiming as plaintiff, of the parties claiming to be inserted as plaintiffs and the other as defendants, and the notice shall be given to all the parties to the agreement other than the parties by whom the application was presented. Parties to be subject to the court's jurisdiction. The agreement has been filed. All the parties shall be subject to the jurisdiction of the court and shall be bound by the statements contained therein. And hearing and disposal. The case shall be set down for hearing as a suit instituted upon ordinary manner, and the provisions of this court shall apply as ordinarily. Where the court is satisfied after examination of the parties or after taking evidence as a thing that the agreement was duly executed by them, that they have bona fide interest in the question stated therein, that the same fit to be decided, it shall pronounce the judgment thereon in the same way as in the ordinary suit. Fifth, sixth, no appeal from a decree passed under Rule 5. So there will be no appeal shall lie from a decree passed under Rule 5. There will be no appeal. Order 36 also contain Rules 6. Order 35, Rule 6. Order 36, Rule 6. In first, we just discussed what type of agreement it could be. Second, we stated that subject matter to be stated. Third, we said that it would be filed and registered as a suit. Fourth, we said that the jurisdiction, there should be the bound by the jurisdiction. Fifth, we have hearing and disposal of the suit, and upon examination is satisfied that the agreement was duly satisfied, bona fide and trust fit to be decided, then the court will pronounce judgment. And sixth, there will be no appeal from the Rule 5 of Order 36. So I think we have done all the three orders from the perspective of prelims. See you in the next class. Have a good day. Bye bye.